welcome all of you to the 40th session. That is, we have completed 39th session and today it is the 40th one. It's a momentous day for us, and who else we can think of, especially those of us who have practiced in the High Court of Kerala than Justice Dama Seshadri Naidu. Sir, welcome to Letils, that is Legal Empowerment Through Interaction Lecture Series, the 40th one. And we are looking forward to have your insightful thoughts regarding injunctions. Today we have Justice Ramkumar sir, Chidambaram sir, and all others waiting to hear you, sir.
What about Abraham Matthew?
Abraham Matthew sir will join. He said he'll be delayed by 10 or 15 minutes. He just sent me a message. He'll definitely, and Nagamuthu sir also said he has got some hearing and he'll also join us.
Okay.
Thank you, sir. Over to you, sir.
Learned advocates, eager students, professional stalwarts, my seasoned colleagues on the bench, past and present, especially Brother Justice Ramkumar and Brother Justice Chidambaram, who are part of this webinar, and Sri Shyampadman. Good afternoon.
Good afternoon.
And a warm welcome. During the lockdown, our legal profession has opened up its mind. It's inviting new ideas. The advocate community has shown remarkable willingness to update itself. I reckon every day there are at least half a dozen webinars across the country. Sometimes we face dilemma about which program we should watch. By now we have attended one too many, and you must have been cloyed. What's meant by getting cloyed? We may like something most, say sweets or payasam if you are a Keralite. But too much of it makes us sick of it. Even our liking for it can't help it. Is my program tasty? Let me tell you. In our experience, with the best and the tastiest feast or sadhya, we still will have pickle. Taken separately, pickle isn't that tasty. It's very salty, bitter, or pungent. But we prefer it because otherwise, too much of good things will cloy our taste. So treat my session as that pickle, salty or pungent or even bitter. Some relief, I must say, for you from the routine. When it comes to today's topic, friends, as you know, it is Injuncting Injustice, an overview of law relating to injunctions. Thanks to Mr. Shyampadman. The title is, I believe, apt. It's a loaded one too. As we will discuss, law has nothing to do with justice. I may repeat, law has nothing to do with justice unless justice, which is nothing but the societal morality, gets the statutory sanction. But people denounce this technical approach. So we have justice beyond law, at least beyond common law, and its name is equity. That's why Shyam called it Injuncting Injustice. And aptly, he did not say law of injunctions. Instead, he said law relating to injunctions. Because be it the CPC or the Specific Relief Act, it has largely codified the equity principles. So it is law relating to or about injunctions. Another aspect is, friends, the expression an overview. Indeed, it is an overview, not a detailed one. First, let me have an overview about the webinars. From numerous webinars, I've noticed one thing particular. A learned lecturer or resource person tells us something, say about a statutory provision. Then to explain that, he brings to our notice some case law then immediately some of us raise our hands. We will say, no, sir, you are wrong. And we insist that the decision he has quoted has been overruled, or the interpretation he has given to that provision is wrong, because so-and-so decision says it's otherwise. It reminds me two things. First, we always believe there is a dichotomy in everything, a division of sorts. Something must be either black or white. Somebody must be either good or bad. Something must be either right or wrong. We don't think of combinations. The shades of color, the shades of personalities, the shades of truth. Especially in legal profession, there is and has always been more than one correct answer. It is highly subjective. I'll come to that later. But before that, let me talk about a BBC courtroom drama. In YouTube, you can watch many episodes of a program called Judge John Deed, a very interesting courtroom drama series. In one of the plays, it is Hidden Agenda. A doctor is accused of killing her cancer patient with an overdose of painkillers because she is the beneficiary under a will or testament. The prosecution examines a senior toxicologist as a witness. Please see her answer to a question which concerns us very much, and in fact, which have been bogged down by. Shyam?
Yes, sir.
Will you play that video? Yes, this is the one.
Dr. Briones, are you the author of Unexplained Death, a study in fatal pathology?
Yes, I am.
What is fatal pathology, Dr. Briones?
Disease of an organ within the body's structure that leads to death.
Isn't that what all death is, Doctor?
Death is the cessation of the heartbeat. In reality, everyone dies of a heart attack. Fatal pathology is what brings it on. It could be cancer, liver failure, a stricture in the airway, or toxins causing paralysis. Many causes are not readily explained.
Would you describe your book as a standard text?
Well, I suppose that's what it's become. It's been a teaching reference for 20 years.
Now, in your book, on chapter 5, section 3, page 157, stasis as a cause of fatal toxicity, you state that when the patient is elderly and suffers from a condition where bodily function slows, metabolites are retained by the kidneys or liver with fatal consequences. Does diamorphine break down into non-excretable metabolites?
In the elderly, where bodily functions slow down, yes. They stick to the molecules that form the cells of the liver and the kidney and can't be eliminated.
Have you examined the liver of the late Mr. Moore?
I did an autopsy. It's clear there was stasis in the digestive system, the blood, the liver and the kidneys. His liver had been retaining large amounts of metabolites from the morphine sulfate and diazepam he'd been receiving. The huge doses of morphine he was given by his GP, intravenously to ease the pain, combined with that retained by the liver, caused first the liver to fail and then the heart.
Can there be any doubt about that, Doctor?
None.
Would a GP be alert to this?
Well, that would depend on how busy the GP is. Most are too busy trying to help people get well, or in this case, to ease the patient's pain.
Would a pathologist be alert to the possibility?
Well, that would depend on the pathologist. We tend to be employed for a specific purpose. We're scientists, but we're human and want to please our employers.
But you tell the truth just the same.
Well, the older I get, the more I realize there are many versions of the truth. I am asked by the defense team to examine a body.
Thank you, Shyam. You have seen the last part of the expert's answer. The older I have grown, the more I have realized there is more than one version of truth. That's what law is all about. Never ever insist on absolutes. Never ever look at the law as a matter of dichotomy. So let's not have the belief that law is fossilized and the legal principles are permanent. Had it been so, we wouldn't have had the so-called landmark judgments, the overrulings, etc., etc. Legal principles are bound to change, and more so when it comes to case law. Though they get crystallized in the form of the pronouncements from the court. And perhaps it's time we came out of the notion that the more case law we know, the more knowledgeable we are. Partly true, but not necessarily so. Here, when it comes to the webinar, all the participants, including me, expect the speaker to be correct as we feel in his interpretation and in his citing the case law. But what do we gain from that? Let me tell you about an experiment in cognitive psychology. There is a good book on the topic, The Knowledge Illusion. It was written by Stephen Sloman and Philip Fanbach. You know what happened? One psychologist at the University of Texas asked a few students to answer a couple of questions. They were allowed to Google for the answer, though. They got the answers from Google. But their engaging in the internet searches increased the students' cognitive self-esteem, as they call it. They believed that they possessed more knowledge. But as you see, actually they were ignorant. It is the machine that gave them the answer. But they believed their ability to retrieve information, I may say, their ability to retrieve information as their ability to answer. So is the case with a knowledgeable teacher. He's our Google. His knowledge is not our knowledge. The bottom line for me is this. If somebody teaches us, we'll come to know things that we have not been aware of until then. So knowing is knowledge. But instead, somebody tells you something strange or unconventional. You don't agree with that. Then you think about it. You try to discover what is correct. Then you find the answer. That is wisdom. I mean, knowing gives knowledge, thinking gives you wisdom. Knowledge changes like case law. Wisdom remains constant like maxims and reasoning. So please, especially my young friends at the bar, learn principles and improve your legal reasoning skills, not case law skills. If you are curious about this principle, please see Motilal C. Setalvad, our first Attorney General's autobiography, My Life. In that one he says, our teachers have taught us the principles. And a couple of years ago, I read an interesting autobiography of an advocate general, a former advocate general of Allahabad High Court. I'm afraid the title missed my attention. I believe it is Experiments in Advocacy. In that one, the author narrates an incident when he was very young. His father too was a senior lawyer. After completing his course in law, this young man joined his father's office, naturally. One day at night, when everybody left, his father, the senior lawyer, started researching a case. He wanted his son, his understudy then, to get him a book that is Rashpari Ghosh Mortgages, Law of Mortgages. That was his Tagore law lecture. Then, in his eagerness, this young man took out the latest edition and gave it to the father. And instead, the father wanted the oldest possible edition in the library. Then he gave the old one. At the end, the son asked the father, "Father, everybody wants the latest one. How come you wanted and insisted on the oldest one? Then this experienced lawyer said, boy, the latest books will have case law, the oldest books will have principles. So either it's Settleward or the Landed Advocate General. The model that I've taken from them is the principles remain, the case law changes. Let me tell you a bit more about neuroscience. I know I have a reputation of not speaking what I meant to and speaking everything else, but kindly bear with me. Let me tell you what happens to our brains, our intellect. If we have ready-made information, it leads to a condition called brain atrophy. You know, London has about 25,000 streets. It has grown historically, street by street, decade by decade, and generation by generation. A neuroscientist in University College of London studied the brains of London cab drivers. You know pretty well, streets means physical places. Physical places occupy spaces. We remember spaces more easily than digits. That is an evolutionary aspect, and let me not go into it. About spaces such as streets, we should have more spatial memory in our brain, and hippocampus was the part that controls the spatial memory. Surprisingly, the London cab drivers, who are semi-educated perhaps, most of them are either Indians, Bangladeshis, or Pakistanis, they had enlarged hippocampi than even a Nobel laureate. And they felt that because they tried to gather more information which is spatial, inevitably that part has enlarged. Lo and behold, my friends, when GPS was introduced, all the cab drivers in London have started using GPS now, and their hippocampus size has come down to the normal. And Daniel Amen, another expert from America, he says this is what brain atrophy is. So friends, if you have ready-made answers at the click of a button, thanks to perhaps Indian Qanun or Manupatra or anything else, if you get answers on the dot, it is the machine that's knowledgeable, not we. This is the Google illusion. May I say the purpose of any seminar is to be original and make you think, make me think as well. I may be wrong, but certainly I'm hopeful I'll make you think. So my friends, someone who refuses to conform to any accepted norm is not necessarily to be wrong. The heretics, as they are called, they make us think. The heretics may remain heretics, but as they make us think, one day we become the intellects. Please remember, all human progress has come out of heretical thinking, not safe status quo thinking. So you gain from a bad speaker more than you gain from a good speaker. And I am that bad speaker for today. When we talk about law, we cannot escape reference to precedent. Precedent is essential in our profession. It's a decisional prop for our argument, but that's not be all and end all. Let me illustrate the limiting power of precedent. A case comes to you. Your client narrates facts to you. Before he completes his narration, your mind races towards a suitable precedent. You have many mental pigeonholes for these precedents. After searching, you find one pigeonhole. You try to put your client's facts into that pigeonhole. They do not fit into that absolutely, of course. So you tinker with the facts, not with the precedent. While drafting, you slightly alter the facts to suit the precedent because you feel it's easy to get your case across before the court, showing that it's been squarely covered. But the client gets lost because that was not his version. In cross-examination, it fizzles out. So long as we are faithful to facts, there's no problem. If we are faithful to precedents, our case suffers. Besides, if you always think of facts from the prism of a president, what happens? Again, if you permit me, I'll demonstrate. Stephen R. Covey, who has just passed away recently, in his best-selling book called The 7 Habits of Highly Effective People, talks about the paradigm shift. Now let us see what happens in the name of this paradigm shift. I'll explain very briefly and get on to the other aspect of the case. Shyam, will you show me picture 1,
Sure.
Old lady?
Yes, sir. This one, no?
There are 1, 2, 3, 4 pictures, Shyam. You can take your time.
So is it visible?
Yes. My friends, whoever is the participant, kindly have a keen look at this picture. I hope you have all seen. Obviously, it represents a woman, and from the rough drawing, you can as well guess the age of that woman. Shyam,
Yes, sir.
now will you have the second picture? Kindly bear with me. It's a novel experiment. Maybe you'll be interested. Now, any of the participants, my friends, would kindly tell me how old is the lady in this picture? Anybody can answer, please.
80.
A rough estimate, whatever age you feel like.
Probably
We can't ask
90s.
women about their age. We can
In
ask
her 90s.
near
80s.
90s.
There are two.
Near 90s. Thank you. Shyam,
Sir, with the due permission,
There are,
good afternoon, sir. It
There
might be 80 to 85.
oh, wonderful, wonderful.
There
You're
are
a
two.
psychologist. Thank you. Let's move on to question number
Child.
3.
Child.
Whatever. Thank you. Thank you. I understand. I take it from you that she's an old woman, right?
no, there's a
No.
young girl also.
Now please look at it. Now please look at it. You have seen it? Now you have seen it?
Yes, sir.
I believe all of you have seen. Now let's move on to the last picture, the 4th one. Of course, 5th one is also there. First go to 4th one.
One, two, three, four.
Yes.
So is it on the screen?
Yes, indeed. No, you have to click on that one.
Okay. Okay, again.
Has to be open.
You have to open it.
Yeah, it's coming, sir.
So far, you are flawless, Shyam. Thank you. Now you have seen the picture. Is it an old woman or a young woman?
Hold
Right?
Young woman.
Young woman.
Both.
Both. My friends, there was an experiment in psychology. You know what happened? Those who looked at the first picture first, they always said the second picture was an old woman. Those who looked at this picture, they always said the second picture a young woman. So this is called, in psychology, cognitive bias. So even before we come across the facts of our case, if we go through case law and we'll have this cognitive bias because we want to win our case, whatever the facts our client narrates, we will convert them to suit whatever that's been said in the precedent. And without our ever knowing, we'll interpret every fact as if it were on a par with the case law. you could have seen in our experience, even the most seasoned advocates, senior advocates sometimes cite case law which is diametrically opposite to them. And we wonder, it's self-destructive, self-code, something like that we say. How come he has quoted that one? This is because this cognitive bias. So, my friends, young lawyers, whenever I address, it's only meant for young lawyers and students. Please remember, whenever you draft the case as it is. My advice, of course, you can take it, you can reject it. And when you prepare on the strength of the facts. And then once you formulate your points, if you feel that you need some buttress, some strength, some prop, some prosthesis to hold on to, then you go for case law, not on the converse. Now, please kindly take, if you have CPC in your hand, could anybody take Order 39, Rule 3? Will anybody read for me?
Yes, sir. Rule 3, sir.
Yeah, Order 39, Rule 3.
Before granting injunction, court to direct notice to opposite party. The court
Yes.
in all cases, except where it appears that the object of granting the injunction would be defeated by the delay, before granting an injunction, direct notice of the application for the same to be given to the opposite party. Provided that, where it is proposed to...
Skip the proviso.
Okay, to deliver to
Yeah.
the opposite party, that's also proviso. Then A, B.
Yeah, you read A.
Okay, to deliver to the opposite party or to send to him by registered post immediately after the order granting the injunction has been made, a copy of the application for injunction together with 1. A copy of the affidavit filed in support of the application, 2. A copy of the plaint, and 3. Copies of documents on which the applicant relies, and to file on the day on which such injunction is granted or on the day immediately following that day an affidavit stating that the copies aforesaid have been so delivered or sent.
Yes. Shyam, you kindly see 3A,
Yes.
Roman numeral 3.
Copies of documents on which the applicant relies.
Now, I will narrate one case that happened in a civil court when I was practicing. One young advocate filed a suit for injunction. The learned trial judge was kind enough to grant an ex parte injunction. You know pretty well that the plaintiff has to comply with Order 39 Rule 3. And he sent notices to 4 defendants in all. He put the plaint copy. He put the affidavit and petition under Order 39 Rules 1 and 2. Then he has annexed all the documents. He has filed 12 documents. So he has annexed all the copies of the documents because you have seen that A3, all documents must be sent. So they were served on the defendants. Then there, a senior member of the bar who is known for his technical skills, he's known as a technical counsel, very technical. He came to the court, filed an application under Order 39 Rule 4 to have the injunction vacated on the ground that Order 39 Rule 3 was not complied with. What he did, earlier when the clients brought the, envelopes, he opened only one. He found out of 12 documents shown in the schedule, only 11 were annexed. So he did not open the remaining 3. He came to the court, he filed his Order 39 Rule 4 for vacating the interim injunction. And he placed 3 Andhra Pradesh High Court judgments, because I was practicing in Andhra then, and identical case where some of the documents were missing. And you know pretty well, courts have time and again have held, including Supreme Court, that Order 39 Rule 3 is mandatory. It must be strictly complied with. Any shortfall in that one will result in nullifying the injunction. So he wanted the court to vacate the injunction because it's not been complied with. Any young advocate may request, what could be your attitude if you are the plaintiff's counsel? Could you think of getting out of this quagmire, this quicksand of sort of things? And mind you, the precedent has been overwhelmingly against you. What do you propose to do? Because Shyam was telling it should be interactive. That's why I welcome you to interact. Don't ever think that I'm probing your knowledge or whatever. Let the ideas flow from. I've been underlining no right answer, no wrong answer. Law is abhorrent of that concept. That's why when there is a 5-judge bench, 3 judges take one stand, 2 judges, doesn't mean that they don't know law. They do, it's subjective. Please come up with your answer if you want to, any of you.
The order can be vacated.
Yes.
And thereafter matter can be heard on merits.
Thank you. Thanks for the contribution, my friend. Would anybody want to join that?
Yes, sir, I agree with it. So recently, I had succeeded in the same lines.
Right. Very nice of you. Because that's been the case. Sometimes it happens.
Yes, sir. Yes.
You know, in Tirupati, we had a peculiar practice when I was in Mafazal court. You know what happens? If I wanted to file a suit for injunction, I should have some cause of action. That is, we plead very routinely and religiously that the neighbor or the defendant has tried to trespass upon the property, and the plaintiff, with the help of the neighbors, has resisted that peacefully. Then he threatened, saying that, come what may, I'll dispossess you. He went back with that threat. So it happens, it's imminent. Please protect my possession. This is the plea we have taken, usually. And sometimes, if the stakes are very high, we ensure that a news item appears in the newspaper about some raucous or some sort of commotion at the site. So we place that also. You know, in that case, what happened? The clerk did not have a copy of this newspaper report that was Exhibit 12. That was missing. So the judge said, Mr. Young man, every day it's been happening, especially the senior counsel has been on a spree getting orders vacated this way. So you have no other go, please vacate. I am vacating. Then the counsel said, no, my lords, please give me a chance. Now, please kindly look at that Roman numeral 3 one more time, please.
Copies of documents on which the applicant relies.
Yes, please. Copies of documents on which the applicant relies, right? Yeah. See, on which the applicant relies is a relative clause, right? It is called restrictive relative clause. In English, it doesn't matter, I'm not teaching grammar, sorry. So, what I would like to underline here is the copies of documents, there is no comma. Kindly notice the copies of documents, there is no comma, on which the applicant relies, right? I would like to say, had there been a comma, the meaning would have been different. And in the last 100 years, punctuation has been standardized and courts have accepted punctuation is one of the accepted norms of interpretation. So you will permit me to legitimately take recourse to punctuation here. I say, you are the court, I appeal to you. I say, had there been a comma, it would have given a meaning, a different meaning. Now without comma, it gives rise to a different meaning. This is my argument. Now, Shyam, will you display that Brennan Martin, I have put 1 and 2.
Yes. This is 2.
Yes. Please read. To give some additional information about the antecedent, that is where the clause introduced by a relative pronoun is continuative or non-defining. The teacher sent for the boy who, etc. I gave him a rupee, comma, which, etc. Now come to the part I would like to emphasize. Note that non-defining clauses are separated from the main clause by commas. Here he has given Renan Martin, the good old faithful grammar book I have taken as an example. My brother, there's no comma, please kindly notice. My brother, who is a doctor, has gone to America. Second one, my brother, comma, who is a doctor, has gone to America. First one is restrictive relative clause. Second one is non-restrictive relative clause. Please have the next slide, Shyam.
Yes, sir. Okay, this one.
Similar one, there must be a second
Yes,
one.
Just 1 second, sir. I'll get
Yes,
it.
yes. Take your time, please.
This one. Hmm? This one, no? Yeah.
Yes, thank you. See what the learned authors have explained. The first sentence without comma implies that the speaker has several brothers and the clause who is a doctor distinguishes a particular one of them. In the second clause, the clause does not define, and the implication is that the speaker has only one brother. Now, apply this principle to this clause 3 of Article 39, Rule 3. Without a comma, what's been said is there are more documents than one, and you have to send to the other party only those on which you are relying. If you are not relying on a document, you need not send that. So what eventually happens is, if somebody has omitted to send one document, he is stopped from using or relying that document during the course of trial. So that young advocate has cited this grammar book and pleaded with that judge, sir, this is the intention of the legislature. I need not send all the documents, and more so newspaper report is secondary evidence that cannot be taken as a document. And the prejudice that could be caused to me is I should not be relying on that in course of trial. I will not rely on that piece of newspaper. So I have not violated Order 39 or 39 Rule 3. So to the luck of that man, the learned judge has accepted and said the precedents cannot be applied there. So he has carried the day. Why I would like to say this is, and to this day, there is no precedent on that aspect. So my friends, Shyam, please take it off.
Yes, sir.
So my friends, let's be original. Let's be original. A president is only a prop that strengthens your case, not transforms your case. Now let me come to another aspect of the aspects that we'll be dealing, what they mean when it comes to the power of original thinking. Is when we are students, we have studied law, and in the examinations, we should be writing about the statutory provision, and we'll be quoting one or two legal provisions, rather case law, I beg your pardon, rather case law, so that we impress upon the examiner that I know some law, I have studied studiously, etc., etc. But the profession, I must say, is altogether a different ballgame. Let me tell you, for every dispute, there are two sides. You accept it. The plaintiff and the defendant, the prosecution and the defense, they both have different points of view on the same point of law. Sometimes, even when the facts are the same, both parties try to put their spin on those facts. You must have heard about the expression called spin doctor. Usually the political parties employ spin doctors, that's means spokesmen. They present the facts in a favorable light. They put a spin on the facts. That's why they are called spin doctors. So both parties cite case law. And in India, the courts sit in panels, unlike in America where they sit en banc. So if there are 16 benches in Supreme Court, practically it is 16 Supreme Courts. If there are as many benches in High Court, practically it's as many High Courts. So when it comes to case law, it will go thick and fast. Either way it will fly, especially in common law jurisdiction. That's why what carries the day in my experience is our narration, our skill to narrate the facts. Well, I do accept, my friends, it is time we talked about injunctions, that it is discretionary, it's equitable, they are temporary, they are perpetual, etc., etc. I assure you, I'm coming to that one. But before parting, let me tell only one aspect, that we have been mastering our skills of law. Many of us, many of you rather, very perfect in the statutes. Any provision you can just reel out, and any case law, especially I am enamored by the skills of career lawyers, as I was there for 5 years. Initially when I went over there, I was amazed at their skill of even an average lawyer will have 1,000 case law remembered. Indeed, it's very studious. But have you ever thought of the art of narrating facts? Please remember, the American school of realism has a different take. When you talk about jurisprudence, formalism and realism, two schools, there are many, of course, I'm not coming to them because that's not our topic though. And formalism says a judge is neutral, like inert gas. He doesn't react. He's an arbiter. He observes neutrally. Then he impassionately hears the facts, applies the law, and pronounces. But in practice, is it really so? At least the American School of Realism of Oliver Wendell Holmes Jr., the American Supreme Court judge, who is also called the Saint of Supreme Court, was said to be the pioneer of this school. He propounded this theory in his book, The Path of Law. There are two books by that man, great man indeed. One is The Common Law, the other one is The Path of Law. Please, if you have time, read them. And curiously, before I could refer to him, let me tell you about another great American judge on this aspect. See, please forgive me, I'm not fond of any foreign things, but since the occasion has come, I'm telling. Benjamin Cardozo, you must have heard about him. He tells us the great tides of currents which engulf the rest of men do not turn aside their course and pass the judges by. Whatever the magnificent events or mega events of the society, the burning topics of the society, they affect the judges also. So many judges across the common law world initially feel shy to accept that. First, they decide the case and they look for justification later, be it in the form of statute, be it in the form of case law. Well, but the American School of Realism insists that is how judges decide. I am no authority to have a final word on that one. I leave it to you, whichever way. But what I have understood is, we always say, when we begin our arguments, your lordship knows. My friends, there could be a presumption that the judge knows the law, but there's no presumption that the judge knows the facts. You are the master of the facts. So all your skill lies in narrating the facts rather than narrating the law. And most of the times, rather it's your experience perhaps, judge, once you cite a decision, once you quote a legal provision. He says that, yes, I'm aware of that. But how does it come to your rescue? But many a time, once you tell him a very vital fact, then he feels, oh, yes, yes, that's not been brought to my notice. You should have brought that to my notice at the earliest point. Then there will be a paradigm shift. That is the real unraveling. So finally, without boring you, finally, I'll have one more video and then back to brass tacks, back to business. I assure you. Please, Shyam, there is one more video,
Yes,
a
sir.
local train incident.
This one, sir?
Yes, indeed.
Subway,
Please, Stephen Arkavi.
very, very large metropolitan city. Sunday morning is quiet, sedate. Bunch of young kids run into the subway. Father follows. He sits near me. The kids just go crazy on that subway, running up and down, turning people's papers aside, just raucous and rude. I'm sitting there, oh, I can't believe this. He does nothing. Now look at my attitude, see? Attitude, you try to control. But look what I could see. After a few minutes, attitude went into behavior. Sir, do you think you could control your children a little? They're very upsetting to people. Oh, yeah. He lifted his head as if to come to an awareness of what was happening. Yeah. I don't know. I just guess I should. We just left the hospital. Their mother died just about an hour ago, and I guess they don't know how to take it, and frankly, I don't either. Imagine the paradigm shift that took place there. Imagine now what the attitude and the behavior would be based upon that paradigm. Can you see why paradigm?
Yes. Now, for those of you who have missed out some of the conversation there, he's Peter R. Covey, the author of that 7 Habits of Highly Effective People. What he says, how we shift our paradigm, he tells a small story there. He says, one day, in a local train, a few people were traveling. Then one father with 4 children, very young ones, got onto the train, tube, local train, whatever you call tram. And he sat in one corner. These 4 children, especially the 3 grown ones, they have been going berserk. They were ransacking everything. In a hot afternoon, elderly people are sitting in one corner, young people were sitting, they were reading newspaper, or they were having quiet movements. But these children jumped on them, tore the papers, created ruckus and everything. And everybody felt disturbed. And they were amazed and also fed up with the father. How come he could sit quietly and just let them do whatever they wanted? It is incivility on his part. That's what they felt. So one young man sitting with his girlfriend, as you could see there, couldn't contain anymore. So his attitude, a protest against him, has translated into action. That's what he said. Then he had told him, look, man, why don't you control them? They have been disturbing everybody here. You could better rein in them. He says, he suddenly wakes up as if he were in a reverie or sort of a stupor. And then he says, oh, yes, it is true. I should restrain them. After all, their mother passed away just half an hour ago. I'm taking them from the hospital to home so that I could do the rest of the things in their absence. That means the mother of these 4 young children died half an hour ago. So from the hospital, the father wanted to take the children back home, entrust them to somebody and go back and do the rest of the things. So the children, having lost their mother, he may not be inclined to control them. Immediately, imagine yourself being one of the travelers there. What could be your attitude towards the children? Just a while ago, we felt they were a nuisance. They were unruly children, raucous group. Now we'll have all our sympathy. This is what the learned author calls paradigm shift. My friends, paradigm shift comes with facts. If you can take my point of view. I've been underlining more so when very seasoned legal humanists have been watching this I have to qualify my statements. They're my opinions. They're not Euclid theorems. You may accept them, you may like them, you may lump them. But only thing is, as I said, heretical I am perhaps, but accept them, examine them, and throw them out if they don't deserve your consideration. So my emphasis is, the advocacy is fact narration. And fact narration is nothing but storytelling. I always advise young lawyers, whoever appear before me, when they are tying themselves in knots to impress the court and to tell anything, I tell them, simply tell the story. Begin something like long ago, because we are hardwired to listen to stories. They are very interesting. You know the story of Panchatantra, said to be the oldest fictional work in world literature. When a king wanted to teach his dunces, dullards, his 5 sons, one Vishnu Sharma came forward and he offered teaching them, and he said, stories with moral precepts. So stories, facts, they matter. Young lawyers, if you want good books on this aspect, may I tell a couple of names you may note down, which I have come across and found to be really good. How Leading Lawyers Think, one book I would like to suggest. How Leading Lawyers Think. Randall Kaiser, it was published by Springer. The other one is Think Like a Lawyer by Frederick Schauer. It's published by Harvard University Press. If you can't write it down, I can as well send an SMS to Shyam, you can share.
Sir, that will do.
Yes. The next one is Logic for Lawyers. It's a very good book. A Guide to Clear Legal Thinking by Rogero J. Alderset. This Rogero J. Alderset was the 3rd Circuit Judge of America. Their circuit judge means on a par with High Court. He's a wonderful author and a judge. Then the final book, Presenting to Win, The Art of Telling Your Story. That's by Jerry Weissman. It's published by Prentice Hall. Now I'll come back. Friends, when it comes to fields of law, we have criminal law, we have civil law. Under civil law, we talk about corporate law. We have international law, we have commercial law, family law, constitutional law, labor law, intellectual property law, then peculiar tort law. It straddles between civil and criminal law. It can be either. That's from professional point of view. From jurisdictional, rather jurisprudential potential, we should accept law regulates our lives. But law in the statute book is cold and lifeless. It gets life when it's enforced. To know how to enforce law, we must indulge in some taxonomy. That means classification. First, we ascertain what category it belongs to. Is it common law, statute law, penal law, civil law? Then a law can be either beneficial, the other legislation can be beneficial, declaratory, so on and so forth. And there can be peculiar piece of legislation. They both are procedural and substantive. There cannot be any watertight division in that sense. You take the example of Indian Evidence Act. It's a mixture of both. You take law of injunction. It's again a mixture of both. Temporary injunctions are procedural and perpetual injunctions are substantive. And we use many concepts. Something like, as I've told just a while ago, injunctions are equitable remedy, equitable, and they act in personam. So what is this equity? What is this acting in personam? So we need to have a spattering of background for this one. And you always wonder, you could have watched a couple of my lectures available on YouTube. Instead of my straight away jumping onto the subject, I talk about the story behind that one. It's sort of meta narration rather. The story about the story. That's what it is about. Because any legal concept is like a person. So let's assume that you're walking one early morning in the park. You're having your morning walk. You come across a person. He waves his hand. and he passes by, you wouldn't recall his face to mind 1 week later because he's not a stranger to you. But imagine instead, he said hello to you. Your retention of memory about that person increases marginally. Then he stops by and tells his name, I am Seshadri. It further increases your memory, retention. Then he says, I'm a judge. It further increases. He says, I am from Andhra Pradesh. It further increases. He says, I worked 5 years in Kerala. It further increases. That means I would like to underline, ideas are like persons. The more you know about these ideas are the persons, the more you tend to remember. So most of the times our learning is imitation. There's nothing wrong in it. Our learning is imitation. For example, again, I address the young advocates. Whenever we read before the court, as I see, we'll say the High Court V-Day judgment number so, judgment dated so and so has restrained the defendant so and so. Or we say the Principal Secretary V-Day communication dated so and so, YD or V-Day communication so and so has directed the Panchayat to do this, that. Please tell me what is meant by V-Day or YD, which we use every day very profusely. Will anybody join me? No compulsion, only to ensure that you don't fall off sleep.
Yes, sir.
Yes, what's meant by V-Day?
It means to see. Latin is to see.
You checked your smartphone.
No, sir, I am knowing a bit.
No, in the light will mean sorry. Because you have told me the exact meaning, that's why I wondered.
Yes,
no,
sir.
See, what happens, whenever you want to use the expression V-Day, it should be there. Please see that one. But we use that in the place of by, through, right? By judgment so and so. Instead, we say V-Day so and so. Hardly anybody uses V-Day. Please make it a thumb rule. Whenever you employ V-Day, the document must be there in the record. If it's not there, you cannot use the expression V-Day. Now tell me another one, please. Ex debito justitiae. What is that one? Because I would like to underline the importance of concepts. Most of the times we use them as a matter of practice, second nature. Never ever thinking a minute, what could be its real import? Could you tell me what's the meaning of ex debito justitiae? If you can, for discussion's sake, don't look at your smartphone.
Or it means in the interest of justice.
In the interest of justice. Thank you very much, madam. Right on target you are. Yes, anybody else? Madam has said, in the interest of justice. Would anybody join in endorsing or opposing that one? Nobody? Madam has the, monopoly on that idea? My friends, every judgment uses that ex debito justitiae with the same meaning, but that is not the meaning. Ex debito justitiae means as a matter of course, as a matter of right. So if you demand injunction ex debito justitiae, it is wrong because injunction is not a matter of course remedy. It is not in the interest of justice. I think when I was in Kerala, I wrote a judgment. You just Google Seshadri ex debito justitiae, you will have whole case law on that one. Anyway, thank you. Why I would like to emphasize is, this is the importance of the concepts. You know, when it comes to equity, we always talk about common law because we are also a common law country. And the whole common law began, as I, a couple of weeks ago in a lecture, elaborated about common law and the concept of precedents. I've narrated the whole story about common law, how 1066, the defining year in English history, where William the Conqueror in the Battle of Hastings has won the battle and annexed England and made it a kingdom, gave it a nationhood. And later he enforced a common rule, centralized administration, and also common law. He appointed his own circuit judges, a group of nobles who are clergymen mostly. They were asked to go around the counties. They were called ayers, counties, and then administer justice commonly. So this is called Curia Regis. Krishna Iyer is very fond of this reference. They have started administering law across the country, common to all, disregarding the local practices. Then, as they encountered same cases repeatedly, they prepared records and kept them in Westminster. They have become presidents. Down the line, by 14th century, these precedents have been crystallized. And if anybody wants to go before this common law court, Curia Regis, they should show to the judge to get a writ. They're called writs. To get a writ, that similar case has already been decided. If there is no similar case decided, you will not get your relief. And sometimes your case may be absolutely different on essentials, but the judges feel it is similar to so-and-so case, so we are dismissing or we are allowing whatever. Then all these consumers of justice, the people were disgruntled. They started complying with the king. Initially, the king started deciding the cases using his prerogative. This is called royal prerogative. Disregarding the common law, because he is the fountain of justice, he can as well decide the way he wants. The flood has begun. Many people were dissatisfied with the common law approach because it's entirely president-based. They disregarded the nuances of individual cases, or a new case could not have remedy. Then he transferred all the cases to the, the chancellor. And that chancellor started sitting regularly. That has become a chancery court. And that chancery court has administered, and it has come to be known as equity jurisprudence. Equity means it is according to the conscience. So the chancellor has decided according to his conscience. Then there is a conflict between common law and this equity. Clients have started playing with these two courts. If you go before the common law court, you get a decree, and your opponent goes before the equity court and he gets a counter decree. If you want to see the play of these two courts, you read any book by Charles Dickens, especially Bleak House. And you know, Charles Dickens himself was a clerk in the lawyer's office then in Inner Temple. So he knows pretty well the whole course. And eventually, the court has found the futility, the king has found the futility of these conflicting jurisdictions. Then they have brought up legislation. They have clubbed both of them. Still, though same courts administer both common law and equity in England, there are differences observed to this day. But as far as India is concerned, when the Anglo-Saxon jurisprudence has come to us, it has come to us mixed. So we no longer maintain a distinction between common law and equity, but we maintain the distinction between common law and statute law. We treat, if I'm permitted to say, common law as one facet of, rather equity as one facet of common law. But to get into the other nuances of this aspect, I would like to tell you, equity is a rebel against the case law. It is entirely a discretionary remedy. Once it's discretionary, usually president has no role to play. That's why even appellate courts must be slow in applying this aspect. Unless the trial court has not followed the established principles, or the decision or exercising discretion leads to absurdity or perversity, appellate courts will not interfere. And you also remember, I'm cutting short and running through, you also remember, when it comes to common law, there is only one known relief, that is damages. But it's very inequitable. I'll tell a very simple example. Suppose you enter into an agreement of sale with A. You agree to purchase a piece of land from A, and you pay part of the consideration, and the part you agreed to pay at the time of his executing the deed of conveyance. Time was stipulated as 6 months or 1 year, though we say that time is not the essence of the contract when it comes to immovable property. Eventually, in 6 months, the price tripled or multiplied. You don't want to sell, rather A doesn't want to sell it to you. So you go before a common law court. Common law court says, all right, how much did you give? You gave him 10,000 rupees as advance. And you have kept, say, 90,000 rupees, the balance with you in anticipation of that sale. That did not happen. So let him pay 10,000 rupees with 5,000 rupees damages. Please go take away. Whereas A gets benefited manifold because of the price. There was no concept called specific performance in common law. Then came this equity jurisdiction where they have said, defendant cannot be unconscionable. He cannot act with a bad conscience. So he can be compelled to do what could be otherwise not possible under common law. He would be forced to do the very specific thing. That's why specific performance has come. So how could this conflict between this common law and equity should be decided? Then in one case called Earl of Oxford's case, in that case, first common law gave a judgment, a decree, and equity court overruled that one. And that led to stalling of justice. Rule of law got affected. Then the chancellor was Francis Bacon. It was referred to him. He ruled in 1615 that the equity prevails over common law. Of course, later in 1873, an act was passed that was called Judicature Act. Under that, everything was mixed, and we need not bother about that one. But this is how the equity has come to India. It has come along with common law. We need not worry about that. So let me come to injunctions. The very known remedies under equity are injunctions, specific performance, rescission, we can say. And there ought to be a well-established legal right on your part that has been infringed. And then the cause of action by then must have arisen. You can as well have your remedies. I was talking about an agreement of sale. When common law could provide no answer, because he would say that I'll pay damages and get away out of this one. Equity has come to the rescue. It only fills the gaps left by common law and later statute law. And why injunctions? Suppose somebody has been doing a wrongful thing. Under common law, there's no way of restraining him. He completes it. And then he says that I'll pay damages. Again, inequitable. Now, you just think of one, though I am very loath to refer to any case law, how equity acts on conscience, I will tell. You know, one couple wants to construct a building. They've entrusted that task to a contractor. He built the house. They initially paid, say, 1 crore rupees. They still have to pay 2 crore rupees. There was about 6 months' time to pay that one. After the completion of that one, they had to check the material soundness of the building, etc., etc. So by the end of 6 months, this construction company ran into difficulties. It was on the verge of winding up, being declared insolvent. So in those dire straits, this builder approached this couple for the payment. They said, all right, they pretty well knew the difficulty. If they wouldn't pay, this company would be wound up. They said, now we are short of money. We can pay you 1 crore. If you want the whole money, you have to wait next 2 years. If you want to sue us before the court of law, please go and sue. It will take 10 years. Sorry? Beg your pardon?
Some distraction.
All right. It will take 10 years for you to recover money from us. If you want right now, we'll pay you 1 crore, but you should give full discharge. and there was no caught between the devil and the deep blue sea. This construction company agreed, took 1 crore instead of 2 crores or 3 crores, only 1/3 they got, and gave full discharge. After that, they tided over the difficulty and filed a suit for recovery of the rest of the money. The owners of the house, the defendants, took the plea of estoppel. And as you know, the evergreen Lord Denning has invoked equity and said they pretty well knew their predicament, they exploited the situation, they acted unconscionably. That's why their undertaking and their discharge in full notwithstanding, the couple is liable to pay. This is how equity operates. Now, equity is nothing but equality. Equity is nothing but conscience. And equity acts in persona. But this is a qualified statement, my friends. Usually what happens, it does not run with the land. This phrase you must have heard. Suppose there is a judgment, originally I'm talking about, when equity was born, there was a judgment against a person by the Chancellor, the Court of Chancery. Chancellor means nowadays Prime Minister. The Court of Chancery. Then, if he doesn't comply with that one, he can be sent to jail. His property cannot be sold. That was equity acting in persona. But now that's been changed. It acts in rem as well. And also, you know pretty well, we all say equity, rather injunction, is a remedy in personam, not in rem. Again, this is no longer valid. There are different species of injunctions which act even universally and in rem as well. We'll come to that by and by. Shyam, may I request you one thing? Hello?
Yes, sir.
And you allotted me 1 hour. I've overshot by good measure by now, and I need half an hour more. Please inquire about the participants. If they feel bored, I can straight away go to question and answer session. If they feel like enduring me, they are welcome, whichever way they feel.
Excellent, sir. We want more. We want more. Excellent.
Sir, please continue.
Sir,
we can proceed.
Sir, all the participants of course, all the participants were with us in this journey for the last 39 sessions. Time was never the first priority.
Thank you. Thank you. Okay. Then,
please continue. More another is, sir. Continuous ga cheppandi. Very much interested to hear.
Oh.
Please continue, sir. Please continue, sir.
Somebody spoke to me in Telugu. That's why I laughed.
Sir, I mean, we have got a good contingent from Hyderabad.
Yeah. You know that story about Janani Janmabhoomi Swargadapi Gariyasi? Does anybody know?
Please, sir.
You know when Rama won the war, vanquished Ravana, killed him, and was flying back to Ayodhya in the Pushpak Viman. Pushpak Viman was owned by Ravana, of course. So he was coming by. Lanka was a very beautiful city, a rich city with all the golden pagodas, diamond-studded walls, etc. And to his credit, Ravana was a great administrator as well. So Lakshmana looked down, flying above, and felt Lanka is the finest one and Ayodhya could not be compared. Then he told his brother, we have won this. It's our kingdom. Why don't we stay here and rule Ayodhya from this place? Then Rama says, Janani Janmabhoomi Swargadapi Gariyasi. You see the power of mother tongue. Somebody spoke in Telugu. I started laughing out.
Radhakrishna Murthy, I'll ask him to teach me also.
Thank you. Now, I don't want to have any definition about what is meant by injunction. It is quite obvious for you to say which way we injunct a person from acting or from not acting. It could be either prohibitive or restrictive or mandatory. I'll come to that by and by. When you think of the statutory provisions, you know pretty well, my friends, I don't want to repeat the college stuff except the outlines, as Shyam would say that. Sections 94 and 95 of CPC, read with order 39, the whole of it, speak about the various facets of temporary injunctions. Then when you want the substantive law on that aspect, section 36 to 42 of Specific Relief Act. As I was telling you, specific relief was also a facet of equity, right? And earlier, there was one provision that was, I believe, subject to correction. Section 11 of Special Relief Act, which said, despite the plaintiff proving all aspects to be entitled to a degree of specific performance, still court in its discretion can refuse. Now, I believe 2018, that aspect has been taken away. Now it shall. So that part, barring from section 36 to 42, the rest of the provisions are statutory, not equity. This is one important aspect you may notice with the 2018 amendment. Then, when it comes to this jurisprudence, this school of deciding, it is not concerned with trifles. See, if your right is violated or infringed, you have a remedy. You know that legal principle, you by just, I by remedium. If you have a problem, I have a problem, I ought to have a remedy. And also, equity does not suffer without a remedy. But the damage or infringement must be substantial. Let me tell you, you have a house, you name that house, say, Parna Kutir. You have named your house Parna Kutir. You have been living in that house for the last 50 years. All your letters are addressed so-and-so, Parna Kutir, so-and-so, so-and-so. Your neighbor has another house. It is called Parna Vishal. Right? Last 40 years, it's been Parna Vishal. One night, he changes his house name to Parna Kutir, like yours. And your letters first go to him and come back to you. There's a lot of confusion. You sue him on that ground for an injunction that he should not use that name. Will you be successful? Please tell me, any of you. You know,
not to succeed.
Why? The reason, my friend?
Sir, he can succeed. I think, sir, he can succeed. That's my opinion, sir.
Thank you. Thank you. You say succeed. You know,
Not succeed.
my friends, occasionally I go to Judicial Academy, wherever it is, Kerala, now Bombay. I carry always a pocket full of chocolates. What I tell the judges there, please ask me the most absurd question possible, I'll give a chocolate. If you ask the cleverest question, that means you are thinking very safely. So safe thinking leads us nowhere. Only absurd thinking leads to discovery and development. So think absurd. Don't ever try to display our knowledge. Think absurd. Then there is the progress. Please tell me, can you succeed?
No.
No. Is one view? Yes, another view. Right. Well, the courts have said no, because no legal right has been infringed. Inconvenience does not amount to infringement of a legal right. Okay. I just would like to underline that the right that's been infringed to be injuncted one way or the other must be substantial. Now, second one is the relief should run with the right, not beyond the right. I'll tell you another case. You know, one person has let out a house to a person, another person, his tenant. The tenant has been carrying on illegal activities, rather antisocial activities in that house. So this landlord sued the tenant for eviction. And the trial court granted an injunction, terminating the contract, though it had been subsisting by then. And eventually, besides ordering the eviction of the tenant, also directed that this tenant should not indulge in any unlawful activities for next 5 years to come. Can you sustain this direction? In the national interest, or whatever you want to call that with? Anybody can answer, please?
That direction will not sustain.
The second part will not sustain, sir.
Second part will not sustain.
Yes,
Second part,
because once the contract got terminated, his liability got terminated, his conduct, which is a moral aspect, is not within the jurisdiction of the court.
Oh, yes.
So the court has been deciding in the name of equity, still that's beyond the bounds, right?
The first part will sustain.
Yes, indeed, very true. But please remember, I said the infringement must be real, not imagined, concrete, and crystallized by the date you go to the court. There is one exception, that is this familial jurisdiction, family disputes. even given their proximity, their cohabitation, even an apprehension will suffice. That is where the equity takes a deviation from the established rules. Now, let me talk about discretion. So what is meant by discretion? Could anybody tell? Quite an obvious thing. See, this is called the elbow, what do you call? Free joints. The fair play, what do you call? Free play at the joints. As in Maneka Gandhi, it's been described. A judge, given a set of circumstances, so the difference between statutory adjudication and discretionary adjudication is this, to my mind, that in a statutory adjudication, A is present, B is present, then C must be the conclusion. In discretionary, A is present, B is present, but that should not necessarily lead to C. It may be something. I'll illustrate. You know, when it comes to law of succession, if somebody is the legatee or a beneficiary after the death of the propositors or the owner, and if this man, to get that property, kills that man, or rather this man is instrumental in killing that man, he is disinherited. This is a common law principle. So, case A, I'll illustrate for your consideration. Case A, one man is likely to get specie successionis, as you call it, likely to get property from his uncle as he is the legatee, and he contrives and kills, he is disentitled. So what remains there? He killed him. Another example, the uncle and the boy, the beneficiary future, were traveling on a motorbike. Uncle was a pillion rider. This man drives perhaps rashly and negligently, causes the death. Is he disentitled? Please tell me. It's a decided case though. Anybody?
No, I don't think so, because even though he wrote, he didn't have intention to kill his uncle.
There was no mention.
Very, very correct, very correct. This is where equity comes into picture. If you applied common law principle, A is present, that is the beneficiary, B, the death, C, disentitled. But under common law, discretion means taking into account the collateral facts. Court is allowed under equity to take care of collateral facts. Once collateral fact says, right, that it could be otherwise, they exercise the discretion. That's why discretion is a rebel against precedent or common law. Now let's move on to the classification of injunctions. Friends, I'm afraid it's the dry part of my discussion with you, because you know pretty well, as clearly as the back of your hand. First category, if I go for that classification or taxonomy, if I use a high sounding word, they're prohibitory and mandatory. You know, prohibitory or restrictive injunction refrains a person from doing some particular act or thing. The mandatory injunction directs a person to perform some positive act. Of course, initially it was conceived that it should be only prohibitive. Later, the legal developments have given rise to this correlative relief for us, that's mandatory injunction. And when it comes to the duration, they can be interim or perpetual. As I was telling you, interim is procedural, guided by CPC. But CP is not the exhaustive repository of that provision. It's only acknowledges, still court has residuary power. It's inherent power under 151. Then perpetual is a statutory, as we see from 36 to 42 of Special Relief Act. In fact, 37(2) says that a perpetual injunction can be granted only as a matter of decree after the hearing and upon merits. And section 38, as you could see, provides the circumstances where it happens and how it happens. My friends, apart from these injunctions, when you think of course, when I practiced in a Mafazal court, I've noticed that every advocate, young advocate's bread and butter is either injunction or bail application. It depends on which side you practice. So one need to be really thorough with the concepts of what is meant by temporary injunction and which are the provisions that attract, what are the parameters, say for example, what is that you have to establish, prima facie case, balance of convenience, irreparable loss and injury, all those things, then the limitations it suffers from. So may I skip all those things so that I can as well spend more time on question and answer if you still have the patience. Now let me tell you about some foreign sounding injunctions, a couple of them only. Quiet time at injunction. Have you heard about this aspect, my friends? Quiet time at injunction. You know, we were talking about all through injunctions based on accrued cause of action. And most of the times you face Order 7, Rule 11 application saying that there was no cause of action. Please dismiss the suit. Rather, whatever. But quiet time at injunction is an exception. It is an injunction in anticipation of a damage. It is rarely given, and one has to establish that the threatened infringement is inevitable. Then only you will be getting it, not otherwise. And I have noticed one peculiar feature. I'll present a practical problem on that aspect. You go before a court of law, file a suit for injunction, saying that my neighbor has tried to trespass upon my property and try to occupy it. Please restrain him from occupying. And this neighbor defendant comes before the court, files his written statement, says, yes, that is his land. I have never tried to trespass. I don't trespass. Sorry. What should the court do? Should the court decree the suit or dismiss the suit? Please tell me.
Dismiss the suit. I mean, he is saying that he has not trespassed.
The defendant has admitted the entire case in the sense that the plaintiff is the owner. He's been in exclusive enjoyment of the property. And I am his neighbor. And I don't intend to trespass upon the property. Then tell me what could be the remedy.
It has to be decreed.
Yeah.
I mean, when he has no intention, he need not be restrained. It should be a deliberate one.
Very well said. There is a Supreme Court judgment, if you care to search that one. Court said, once there is no list, there is no dispute, there is no issue, the party to join, there should be no decree. It should be a dismissal. Because the defendant's undertaking that he is the owner, the neighbor is the owner, plaintiff, and he wouldn't be interfering is a matter of record. Second aspect I'll tell you.
Sorry, inko mata. Janani Janma Bhumi.
Please speak in Telugu, English. For the benefit of all others. Otherwise, they may think that we are talking something foreign.
No, nothing of that sort.
Yes.
I also practiced in AP High Court and Chapatam Gurin Chantakante. Okay, sir.
Thank you. Right. Now, I'll present another aspect. I file a suit for specific performance. Let me put it this way, that I say that the defendant has undertaken to do this one. He is not doing it. And the defendant appears, files a written statement, says that, yes, I've undertaken, I'll be doing it in course of time. Do you decree the suit or dismiss the suit?
We decree that he will be doing in some stipulated time, that we may take note of it, sir, and then we may make part of the decree and accordingly will decree the suit. That's what I think, sir.
Okay. According to decided cases, I may say it should be dismissed. I'm talking about one House of Lords case, identical case. What they have said, once a party is willing to perform his part of the contract, he cannot be commanded in the name of a judicial directive. His undertaking anyway is a part of the record, that will suffice. So at least that is the case. If you are the judge, you may decide. That's what I say. It's judge specific. We are talking about because one particular judge has decided in a particular way, but that cannot be all and end all or immutable aspect of law. It could be different, in fact. Now, I have talked about quiet time at injunction, a prohibitory anticipatory injunction. Now let me come to super injunction. Have you heard about this super injunction? In India, there was only one instance. Delhi High Court has given it a couple of years ago. Otherwise, so far it's not been applied. And there's been a lot of debate whether India can have such an injunction in the face of Article 19 of Constitution of India. If you have not heard, I'll straight away go into that aspect. If anybody has known about that one, they could as well tell so that we can have some discussion. Super injunction.
Not heard, sir.
Yes, super injunction is the latest. My friends, kindly remember one thing. Injunctions is, as an equitable remedy, an evolving field. They are not being stratified and structured ABC and nothing beyond. Extraordinary situation demands a remedy, as you say, justice, equity, and good conscience. Based on that, courts can evolve any number of remedies. It is the mischief that's to be remedied, the unconscionable conduct of the defendant that has to be stopped. For that purpose, your imagination, your judicial innovation is an answer. So courts have been coming up every now and then with one form of injunction or one form of judicial relief or another. The super injunction is one such development in the last 1 decade, not beyond that. A super injunction means it's called privacy injunction or gag order. See, for example, it is mostly by the celebrities. Suppose there is a celebrity, a very famous film artist, let me put, because we are fond of films. His wife files for divorce on the ground that he has an extramarital affair with some other actress or whatever. We are all adults, we can discuss this legal aspect. Then, my friends, until the case is decided, he contests saying that I have never had any relationship. If the media carries this news, they'll have a field day. His supposed integrity or reputation is at stake. So he applies to the court, kindly restrain the media from reporting about this case. Right? Then what the newspaper does, it will have headlines. You know, it will have headlines saying that there is a case involving so-and-so, but sorry, we should not report because court has restrained us. That is enough for us. That is enough for us to start inquiring, right? That leads to our knowing what it is. We'll go to the court and we'll inquire because we're curious. Long back during emergency, Indian Express was subjected to pre-publication censoring. The then government or the authority concerned at the time said so-and-so article should not be published. So by then they had published it in a sense in the model newsprint. What the Ramnath Goenka did cleverly, he kept the whole area blank to let people know how much has been censored by the government. So this is what happens here. So this super injunction takes care of this aspect. That is, this newspaper should not report even about that injunction restraining the newspaper from reporting. So I call it a black hole injunction. You know, black hole, it sucks the light. That's why you can't see that one. Any object, only light reflects, you can see. But black hole sucks the light. That's why they are invisible. So is this gag order or super injunction. It can't be reported about that one. And now, when it comes to 19(1), I wonder whether it could be sustained. But as far as England is concerned, they don't have that constitutional constraints. There it's been given left, right, and center, this celebrity injunction, gag order of sorts. But, you know, recently, the other countries have picked up. Say, for example, in England, it's been barred. USA, some newspaper will pick it up. Now, England courts have reached one step ahead, and they have started using universal gag orders. Again, with the treaty countries, it may be possible, not with other countries. Anyway, that is about super injunctions. You can explore further if you want to know about it. It's an evolving branch, not much case law is available, barring a few cases. Now, let me tell you about John Doe injunction. Any idea about John Doe injunction, please? In India, they have been given very routinely, especially Delhi High Court and Bombay High Court. These are the two high courts that have been regularly giving. Other high courts may have been given, but As far as the reported cases are concerned, I've come across only these things. John Doe injunction means we were talking about injunction being in personam. It should be against a particular specified named person. But John Doe injunction is a universal injunction. Here, it is in a sense in rem injunction, not in personam injunction. It's given against anybody, anonymized injunction. It is called anonymized injunction. I will tell you how it happens. You must have seen one beautiful case from Bangalore about 10 years ago. There, one person filed a caveat under 148A, section 148A. He did not name the respondents or defendants in the caveat. He said, he told the court, my difficulty is this. I have a piece of land. Some land grabbers have been trying to trespass and occupy that one. If I name ABC as the defendants and file injunction, then DAF file the suit and get an injunction against me. If I name DAF, then GHI come. So please, my land is identified. Let there be a caveat concerning that land. If anybody files a suit against concerning this property, I should be notified. But the rule says it should be specific vis-a-vis the person. Then the learned single judge, when it's called on bench, refused to number it. It was referred to a division bench. My vague memory, I may be pardoned for that one. It was referred to a division bench. Then the division bench has held it cannot be possible. No, sorry, it was possible. Then somehow it was referred to a full bench said, no, it should be person specific. There cannot be universal caveat. Now, John Doe injunction talks about this universal injunction. I'll tell what happens. Suppose you made a film. It's mostly issued in Indian context vis-a-vis the films and softwares. You have made a film. You want to release it. You release it. Then these piracy people, they copy it. And they put it online, and without anybody's knowing the origin, it gets across through the network. That there is a particular name for that web network. Through that one, it spreads. So nobody knows who spread it, but the film is out and everybody watches it. That's why it's impossible for the plaintiff to identify the person and seek an injunction against him from not doing. But he knows the service providers who host it. They don't feed it. They don't upload it, but they host it. So if a suit is filed for this John Doe, simply John Doe means unknown. As we say, anonymous, in English courts and American courts, the practice of if there is a restriction about naming a person because of various privacy reasons, they call that person John Doe. You've heard about Roe versus Wade's case, the famous abortion case in American Supreme Court. Roe was not the original name. It was a pseudonym. Similarly, John Doe injunction is against unknown persons. What happens? The court says, whoever uploads this one, the service providers such as, it could be Google, it could be whoever, they should take off. They should take down this one. This is John Doe injunction, which is universal, anonymized injunction. That's why it defeats one of the cardinal canons of equity law, that it's in personam. No, sometimes under extraordinary circumstances, it acts in rem as well. Now, let me come to Mareva injunction. Mareva, my friend, Mareva injunction cannot be called an injunction. It is at least at best an order. That is a freezing order. Attachment before judgment. In a sense, attachment before judgment, the English people call Mareva injunction. If you look at Order 39, Rule 7, it specifies that one. And then Anton Pillar injunction. It is nothing but the search order. Again, Order 39, Rule 7 contains all provisions concerning whatever the injunctions the other countries have felt that they have been evolving now in 70s, 80s, 90s. No, we have had them from the beginning. But the two injunctions that have not been there with us until now are John Doe and this one. What is that? John Doe and
Mareva.
Not Mareva. Super injunction. These are the two species we have not been aware of, but now we have adopted them. Now, having talked about these injunctions, You know pretty well, the entire Order 39 is an offshoot of equity. Courts have repeatedly held that Order 39 is not exhaustive. A relief you have sought may go beyond that and fall beyond that one. Still, court can grant the relief under certain circumstances, invoking its inherent powers. And so is the case with from section 36 to 42 of Specific Relief Act. There is substantive relief, but it should be based on the merits of the case. There, the element of discretion is quite restricted. Now, what are the aspects you have to establish? You have to establish prima facie case. Well, prima facie case cannot be confused with prima facie proof. The court must only be satisfied that there is bona fide dispute raised by the applicant or the plaintiff, that there is a strong case for trial which needs investigation and a decision on merits. And on the facts before the court, there is a probability of the applicant being entitled to the relief claimed by him. This is what we are talking about, prima facie case. Then it must be causing irreparable injury. You know, initially, every remedy was viewed in the common law as a matter of damage. But that has given rise to some unconscionable bargain in the hand of an unscrupulous defendant. So then this concept of irreparable damage has come. What cannot be compensated in terms of money? See, anything can be measured in terms of money, but that should be in real terms, not in notional terms. There are certain parameters we have to follow with regard to whether something can be redeemed by way of damages or not. Again, there is a wide element of discretion, that one. Now, finally, let me come to balance of convenience. You know pretty well how it swings, what mischief, the comparative hardship the court has to look at, and all those aspects. Now, there are other aspects that can be thought of where injunction can be refused. When you think of section 41 of Specific Relief Act, it couched in mandatory terms, injunctions cannot be granted as it has enumerated from A to J of that provision. You can as well look at it. Now, finally, let me tell you about what are the factors that disentitle a person from a relief that is equitable. For example, laches in the sense of delay. If something happens, equity abhors indolence. One should be really vigilant. If he delays, then the best of the rights get disused and he may not have relief. Then laches in the sense of acquiescence. For example, your neighbor right under your nose has been constructing a building and you wait quietly for 6 months and it builds up to say lintel level or whatever ceiling level. Then you rush to the court and say that stop it. Though you may have a wonderful case, still court can say there have been acquiescence on your part or passive observation on your part, and then that amounts to laches. And also, you should be coming with clean hands. Equity demands equitable approach on the part of the person who comes to the court as well. That's why clean hands plays a very vital role. Please tell me.
In these COVID days, our hands are cleaner.
Indeed, we very clean hands we are. But the problem is courts are not functioning fully. That's why we may not get injunction. Then we may think of third-party interest as well. If at all it has already given rise to third-party interest, then again, court is very rather slow in granting the injunction. Now, I may as well visit the statutory provisions and explain each aspect, etc. I believe it's better we indulge in some sort of a discussion. More so, it's flanked by scholarly persons around. May I say that and hand over the reins to Shyam for that discussion to be initiated?
So thank you very much, sir. Can we just go to the queries that has been raised straight away, or should we have a discussion first, sir?
No, it's up to you. You are the master of the ceremonies.
Thank you, sir. Seena has got a very good question that has been posted in the chat. Seena, can you just come forward and ask the question?
Good evening, sir.
Unmute yourself.
Sorry?
It's done, sir.
Yeah.
It's done, sir. Good evening, sir. So my question is, when the injunction order, sir, when it will come into effect, means it will be communicated to the other side. So said about the universal injunction, I think it is John Doe injunction.
John Doe injunction.
Yeah, I don't know the correct spelling. Anyway, it's John Doe injunction.
John-DOE.
Okay, okay, sir. Sir, in that injunction, if there are no such defendants, how we communicate the injunction order to the other side so that that injunction order will come into effect, sir?
See, it depends on practice. Usually, once you obtain John Doe injunction, it is published.
It's published in the newspaper.
It's published, say in newspaper. Then
Okay.
it amounts to notice to the world.
Okay, so then
You're
there is
getting
no-
it and keeping it in records will not serve the purpose. It has to be notified. It has to be publicized. And it could be in different forms.
Okay, sir.
And
So
one of the forms is newspaper publication. Then web notification if you want to. Yes.
Okay, sir. One more aspect is whether there is any effect of this Order 1 Rule, I mean Order 1 Rule 8
See,
notification or anything of
even
that kind.
I filed a suit and got injunction when I was practicing. I got money, but the petitioner, the producer, did not get any protection. The next day, I saw that online as usual. But still, people have been fighting for that one. Every Hindi movie that's released, first they apply either in Bombay or Delhi, they get John Doe injunction, then only they release it. That's the practice. At least to some extent, they are containing, if not entirely. Its efficacy is being felt. Maybe in course of time, it picks up.
Okay,
Maybe
okay, sir.
Sir, at least for the time being, a deterrent so that others may not freely indulge.
Yes, indeed. It's a sort of a deterrence.
Okay, sir. This there is any effect of this Order 1 Rule Rule 8 effect, sir? So that we need the publication in that aspect.
No. We cannot import that concept of representative suit there. Order 1 Rule 8 doesn't apply to John Doe injunctions.
Okay, so
Yes. There's no known person to represent the other unknown persons.
Okay.
Here,
okay,
everybody is unknown. In John Doe, everybody is unknown.
Okay. Okay, so my next question is whether this John Doe injunction that is recognized by our CPC, the Code of Civil Procedure.
Yeah, see, there was one beautiful judgment, some Heminder Gupta versus Union of India, something like that one. Justice Markandeya Kudzu wrote the judgment. In that one, it said, for everything, we don't need the legal imprimatur or legal permission. So long as there's no prohibition, that will suffice. If law prohibits something, you cannot do. Law need not permit you to do something. It's inherent in you. You can do whatever, so long as it's not been prohibited. And injunctions are open-ended legal reliefs. That's why they don't need any enumeration. And they don't need any judicial imprimatur or permission. Yes. So long as it doesn't infringe any law, you have a right to maintain that one. Yes, please.
Okay, sir. One more aspect, sir. I'm sorry. I don't know.
No, you're welcome.
Okay, this is a foolish question, might be, sir. So my question is whether that injunction that can be implemented here in Kerala in any of such cases.
Kerala is part of India.
Okay.
It can be implemented, I believe.
Okay, so far I never heard such an injunction. That's why.
Yes.
Thank you.
No, at least 50, 60 injunctions have been given. First case was Justice the Ashok Kumar case. That's why it's called in India Ashok Kumar injunction.
Okay, okay, sir.
Yes.
May I get the citation, please, sir?
I don't.
Let's see, definitely. We'll
Okay, okay. Thank you, sir. Thank you.
Sir, a question has come in connection with what Sina has said. That is, the question is, if there is no need to mention against whom it has to be filed, without a defendant, how can a suit be sustained to get an injunction in that?
My friend, extraordinary circumstances give rise to extraordinary remedies. This is what judicial innovation in the experimental field, right? You think of summary jurisdiction under Order 37. When that was introduced, everybody was agape. How could that be? In 10 days, I had to come up with my defense. As a precondition to defend, it's my right. But still, they presume that I am wrong and they want me to deposit the money. But that was the need of the hour. So is the case with John Doe. Technology has, obliterated the boundaries. So law has to rise to the occasion.
Isn't there any need for any legislative intervention in that field?
I don't think, see, common law has not been abolished in India.
Correct.
Statute need not be the answer for everything. Wherever statute is absent, the crevices or the interstices, as they call, can be filled up with these things.
Correct, sir. Nitin has put his hand up. Nitin, can you just come forward and put your question?
Yeah, namaskar, sir. My question is not per se relating to the injunction, but it was relating to the discussion which had happened. Sir, you mentioned that we must be the master of facts. But most of the times, we often find it out whenever we are trying to tell certain facts, which is very much crucial. Many a times, we don't get chance to express. Maybe there are some kind of advocates who actually speak sometimes irrelevant. So sometimes we are ignored. So how to come in that? I mean, how to come ahead and mention those facts? And because those are very much crucial. So how do we have to how do we have to do this?
Presently, one of the best advocates in India, you could say, Mr. Venugopal, right?
Yes, sir. Yes, sir.
Right. And I was told about him, a peculiar habit of him, subject to correction, it's anecdotal. Wherever he goes to argue a case, say any high court, you entrust him a brief senior engagement and he comes over to say Kerala High Court or Madras High Court, wherever, his habit is to go at least a couple of hours in advance, sit over there, notwithstanding all his seniority and knowledge, observe the judge and modulate his arguments as per the needs of the judge. Everybody has his own peculiarities. Everybody has his signature conduct. Some judges heavily rely on facts. Some may not pay much attention. It's an individual taste. You can't account for that one. So my friend, what I said is, on a broad line, it applies. As judges, we are more interested in facts because there is a way to correct the law at any stage, but factual correction is very difficult. So we look forward to having the correct facts. And once correct facts are narrated, law falls in its own place as a corollary. So I left to myself as an individual, as a judge in adjudication, I value more assistance from the advocates when it comes to the facts. And there are advocates who refuse to divulge the facts. They straight away jump into the middle of the argument. This is called knowledge bias in psychology. What happens? Your client comes to you, he enters the brief, he narrates the facts to you, you draft it, then you conduct the trial, and then you argue the case. By then, you internalize the whole case. It's become second nature. But the judge is a stranger to that one. The knowledge bias is that whatever you know, you also imagine the judge knows. That's why straight away, you take a point from the middle, a strong point you presume, and you argue. But the front, the back, judge doesn't know anything. So that's why I've been emphasizing advocacy is nothing but storytelling. Please tell us a story. We're all interested. Yes.
So we have Harshida Manklani with a question. Harshida, can you just unmute and put a question?
Sir, my question is whether John Doe injunction can be obtained in case of advertisement inviting recruitment under service law.
I don't think it's possible, my friend.
Because many candidates applying.
There should be an infringement of your right. And that infringement must be a certainty by an unknown person. But here, what is the infringement of your right to go for a John Doe injunction vis-a-vis an advertisement? If somebody advertises for something and you feel that is wrong, that person can be identified. Here, there's no identity of the person who puts that, who uploads that video. There's no way of your knowing. That's why John Doe injunction. If somebody recruits or tries to recruit and goes for a public notification, you know the person, you can identify, you can sue him for whatever damages you want. As far as my knowledge goes, I don't think it's possible, Harshita.
Okay, sir. Thank you, sir.
Thank you.
Now we have got KP Manoj. Mr. Boban, if you can please mute yourself, it will be very helpful. Thank you. KP Manoj, please. So can I read out the question that is posted?
You can.
Is the relief of compensation for obtaining injunction wrongfully is temporary in nature? I think maybe we can get compensation for obtaining injunction wrongfully.
See, it's a very good question. Actually, there is a subtle difference between damages and compensation. First thing. damages come under common law, compensation comes under equity law. This is one thing. If they want to probe, they can probe further. It is not the forum to explain the distinction. That apart, you know what happens now, as equity and common law has been combined, in the same suit, they can get common law relief of damages and also equitable relief of injunction. Suppose there is a breach. Up to now, the breach has been completed. There is a possibility of future breach. You as the plaintiff is entitled to compensation or damages for the breach that has already happened, and injunction not to repeat that one in tortious liability. So both can be possible. So it can't be said to be temporary. And there are extreme cases where they said, even with regard to future breach, there can be damages. But it's only a theoretical proposition. Yes.
Correct, sir. We have got Tanaya with a question. Tanaya, can you just put your question?
Yes, sir. My question is, my question is, what is the difference between an interim injunction, like the ones which are granted in IPR matters for seizure and destruction of the infringing material, and Mareva injunction? And my question is because the purpose of a Mareva injunction is also for dissipating the defendant, for preventing the defendant from dissipating his assets with an intention to frustrate a prospective judgment.
Yes,
so
very true.
The difference between these? What's the difference between an interim injunction and a Mareva injunction?
See, when it comes to Mareva, you know this Anton Pillar and Mareva, that is search and seize. They usually go together. You know that one, right? More so when it comes to, these industrial disputes or supply disputes, international supply disputes, and also this, software disputes. These things do happen. Let's take an example. There is a manufacturing company. It gets raw material from other sources and it prepares or manufactures the end product. So company A has supplied a particular component, and then having received the components, it has failed to pay the consideration for those components. Then he files and he seeks this freezing order. Such unfreezing, you know what happens? Based on the court direction, the commissioner appointed by the court goes over there, because tomorrow, if he destroys these components, he will say that there was no contract, he has never supplied to me. So he needs that one essentially that has been supplied. That's why Article 39 Rule 7 says the same thing. So here, the destruction doesn't arise. As you said, the incriminating material or the offending material like copyright violated destruction, that's only after the verdict. Here, the seizure and its safeguard, unless it's perishable. If it's perishable, it can be sold in public auction and the proceeds can be kept aside. Other things which can be preserved, they can be preserved under the supervision of the court. And eventually, once a judgment has been rendered, then a call can be taken by the court what to do about that one. I don't think this seizure and destruction go together. There are two phases.
Thank you, sir.
Thank you.
We have Vaibhav Kanolkar. Please, Vaibhav.
Yeah, my lordship, if I may kindly address my question.
Yes, Vaibhav.
Yeah. So my query is that, especially what we observe in cases of family matters is that when the matter is sub judice under 498A or something, it so happens that to pressurize a party and so that they go for reconciliation or so that they take back their petition for divorce, the wife of the husband, in case the husband has filed the petition, tends to forcibly enter into the house. In this case, many a times you observe that in Bombay, when we move a petition seeking for ad interim or interim relief as regards to injunction to refrain her, it is called upon for the reply of the other party and things get prolonged. So the whole very purpose of trying to restrain her from entering into the house seems to be a failure. So could you please throw some light or guide us on how should we go about all this, in this, especially in cases of family matters?
Vaibhav, you're very right. Though I cannot comment about a particular court's approach or whatever, especially in other countries when it comes to matrimonial disputes, this is a restraint order, is a very routine order. Usually, there, the husbands tend to be very violent and abusive, etc. So their safety is at stake, women, the wife's safety, more so with their free access to weapons in a country like America. That's the primary order they expect at the very beginning of a matrimonial dispute. Sometimes that tends to be very ugly. So as you said, based on the facts, perhaps maybe the courts should have a broader view on this aspect instead of insisting on the technicalities. It's only my personal opinion, I must say, Vaibhav.
Okay.
Instead of insisting on a technicality that I should put them on notice, then only I can do. By then, as you said, position may become irreversible. But
Right.
as you know, it being a discretionary one, the judge has quite a leeway in that matter, and he is the best that decides.
Okay, thank you, sir. Could you cite any judgment regarding, sir?
No, I am against judgments.
Thank you. Highly object.
My school is reasoning school.
Okay, thank you, sir.
We have Shaiju with a question. Shaiju, please. Shaiju, please unmute.
So, sir, with respect to the new type of injunction, hearing of new John Doe injunction and Maraiva injunction, which courts are having the jurisdiction? What are the provisions?
All civil courts have jurisdiction. Whoever can entertain Ardhatna Rule 1 and 2 can entertain John Doe, super injunction, all these things. There are no separate forums for them.
Yes, with respect to the defendant aspect. So whether it is a like suit or temporary injunction nature or in decree, permanent decree in nature.
See, here, most of the times, you know what happens? Super injunction is a temporary injunction until the proceedings end.
Okay.
John Doe injunction, the moment it is issued, it is as good as disposing of the main suit because there is a restraint order. Tomorrow you release your film or you do something about your software, then there ends the matter. But there are stages when it comes to both of them. John Doe can be perpetual or temporary, but super injection is usually temporary.
Okay. The provision to be quoted.
Sorry? It's breaking. Your audio is breaking, my friend. Shaju?
Is there any specific provision? Shaiju would like to know if there is any specific provision.
Neither common law nor equity law depend on provisions. It fills the vacuum left by the absence of statutes. And as the reliefs are variable, innumerable, legislature has advisedly left that field open. It is not conscripted.
Okay.
Yes.
Okay.
Damon, you put your hands.
So I am asking about whether we want to put a 151 also. Since
yes, 151 ubiquitous.
It is an answer for you.
Okay.
Yeah.
Okay. Thank you.
Sir,
Okay, thank you.
My question goes along with this, though I would raise my hands long back. When
yes.
When Mr. Shyam asked me a question,
those who wait will also be served.
Sir, when Shyam asked you a question whether there is any need of a legislative intervention, your answer was a big no. But I see why can't be a law on that, because we all know under what circumstances and in whose case. And that happened in the midnight of in Delhi High Court. So that privilege may not be applicable. That will not be available to me or Shyam.
Why?
So,
why not?
So why can't there be?
Why is not available to you?
That was law on that, because
Delhi advocates and we practice the same law. Whatever is available to them is available to us. What way are we handicapped about?
I'm asking. I'm speaking about that particular plaintiff. Because of his privilege only, that's a fact. Otherwise, if the same thing is applicable to us, me or that's what I am telling. So that will not happen. So why can't there be a law? If there is a law, that is.
If there is law, nobody is going to say no to it. Correct. What I say is, for every conceivable situation, we cannot think of legislation. It's a laborious, time-consuming process. Courts cannot wait till then. That's why in common law jurisprudence, law is the latest development. The other aspects, so long as they are there, they can be used. For example, you take Vishaka versus Rajasthan. See, that was kept saying that these are the guidelines in the absence of legislation. Later legislation has come. It can come always. Right.
That's sure. That's what I am asking. Why there should be a no to that? Because it's not required. But
that question to Assembly or Parliament, not to me.
Yes.
Yes, next question, please.
I have Ajita CG with a question. Ajita, please. Ajita, are you there?
Yes, I am here.
Very good. Question? You again muted yourself. After that, yes, you
Yes. Yes.
now you can go along with it.
Yes, Ajita.
Yes. And with regard to anti-suit injunction, my lord. In is it in Indian courts, is it familiar with anti-suit injunction?
Which is the provision under specifically fact anti-suit injunction?
That will act like as a caveat, my lord.
No, section 41. Section 41 speaks of anti-suit injunction. Please tell me what's your doubt?
My doubt is that I have seen across one decision of the Supreme Court in which anti-suit injunction has been granted. But in Kerala, that is not been seen granting. Anti-suit injunctions are not familiar with the court.
See, the problem is we have to break the new grounds. You know, sometimes we tend to be quite conservative. Whatever our senior has done, we tend to replicate. Whatever we do, next who follow us, they tend to replicate. That's why think out of the box. Think of the new remedies. You know, I'll tell one simple example from my career. When I was practicing in Mafuzal, one old man came to me and gave a promissory note saying that his own nephew borrowed money from him. He refused to pay. Then I filed a suit, and it took 1.5 years, 2 years to serve the notice summons on that man. Then written statement, before that was amendment, again 2-3 years. By then the man fell, broke his hip. Every time his sons would carry to my house on their shoulders. One day he told me, boy, I was young, boy, in my lifetime, can I ever see that money? I felt very bad. Then onwards, I started filing suits, especially based on contract and negotiable instruments under Order 37 summary jurisdiction. Incidentally, I was the first person in Tirupati to file that suit. Believe me, none of the advocates has cared to read that provision and meet me or challenge me. Instead, they came to me, please don't teach judges new things. If you want a decree, you wait for 6 months, let me collect my fee, and we can have it. After all, money suit, what is there? You will get the decree. But why do you want all these methods so that tomorrow all cases would be over, we would be under the tree without any brief? So this is the conventional attitude. What we are forgetting, the faster the cases get disposed, the more cases come because people get faith on the system. So think out of the box, think of the new remedies. Why do you go in the beaten track? Yes, please.
Yes, thank you, sir. We will try to.
Please do it.
Thank you. Harish Babu, please.
Good evening, sir.
Yes, Harish.
Sir, you told us that mastering of facts is more essential.
That's my personal opinion, Harish.
Yes, sir. My doubt is, along with mastering of facts, is it always advisable for an advocate to fully equip with the precedents in the matter so that he knows whether his relief will come in the pigeonholes of the law?
Harish, which language is your mother tongue?
Pardon, sir?
Which language is your mother tongue? Your mother tongue?
Malayalam.
Malayalam, okay. No, because the name suggests otherwise. There is a saying in Telugu that is almost sort of a gender biased statement. Those days that was true, not these days. That's why I tell you. There was a saying that if daughter-in-law goes to mother-in-law and says, I would like to give you a grandson, do you have an objection? Because those days they would like to invite grandson into the family instead of granddaughter. They felt that was a burden. Now discarded theory through. But in our Telugu there was a saying, if daughter-in-law is prepared with that one, mother-in-law is overjoyed. If you, apart from narration of facts, if you are equipped with case law, you are most welcome. You will be a complete advocate. And
Okay.
every mother-in-law is happy.
Prime.
Yes,
Yes, sir. It was a really fabulous session, and what would I say that you have injected the whole concept of injunctions to our minds, drawing every participants in, and almost like holding their attention all throughout. Never there was a dull moment, I would say. Thank you so much, sir. Thank you so much.
Thank you very much.
So may I request Justice Chidambaresh and Justice Ramkumar sir to offer some comments.
Yes, my gurus.
Not at all.
No,
Splendid.
brother, I value both of you intellectually very highly. It's my true opinion.
Splendid lecture. I wish I were a young lawyer before you. practicing for your courts, so that I could try new vistas of jurisdictions.
Thank you, brother. Thank you.
Chidambaresh sir.
He heard CPC with literary flavor. It was a treat, not only to the ears, but also to the eyes.
Thank you, sir.
Thank you, brother. Thank you.
So, what can we say, sir? I mean, we at this Legal Empowerment Lecture Series, we have been traveling together. These are all persons, I mean, all these participants from different parts of the country, and with the guidance of Ramkumar sir, Abraham Matthew sir, Chidambaresh sir, all were kind enough to be part of this journey, sir. Today,
What happened to Abraham Matthew?
Abraham Matthew sir, I don't know, sir. I mean, I just called him after. I mean, he said he'll join, but I'll definitely say I'll
Okay.
Shyam, it's my privilege to be part of this 40th session. In Bombay, in entire Maharashtra, I am only known as Kerala Judge. I truly am Kerala Judge, and it's my privilege to be part of all of you. Thank you.
Thank you very much.
Shyam sir, one request to you from my side. If sir can again come and deliver such lectures, if you can request us, sir.
Our standing request, Nitin. It is not as if we have not been. This time we trapped him today, so we'll again do that. We'll try our level best.
I look
So
forward.
now, sir. So, sir, we request sir you come again, and it was very nice lecture.
Choose a good topic. We'll be back again.
So that's very kind of it, because we'd like to keep this going, and these sort of perceptions from different angles, of course, broadens our horizons of viewing things and perceiving things. So thank you very much, sir. That brings us to the end of the 40th session. It was, in fact, wonderful and great to have you, sir, with us. Chidambaresh, sir, thank you very much. Ramkumar, sir, thank you very much. And each and every one of you, thank you. Tomorrow, 3:30, we'll meet again. We'll have the topic being arbitration. We have a wonderful speaker and even for wonderful moderator. We'll meet tomorrow. Till then, take care. Stay safe. Thank you.
Thank you, all of you.